Let's begin with opening prayer. Dear Lord, thank you for bringing us to the beginning or close to the beginning of a new month. Thank you for all of the blessings you have given us and help us to understand what our lesson for today dealing with the Supreme Court and help us to learn what it is that ours is going to be decided and how it's going to affect the future. In Jesus' name, amen.
So welcome everybody to Youth Prophecy Group. This is meeting number 131. And today is May 5th. Just
The title of today's lesson is Decided and Undecided, the 2024 Supreme Court.
The Supreme Court has the power to alter the events of the United States for years to come. Many of the decisions directly involve subjects we as a movement should pay attention to. In this lesson, we will look at a few of these court cases, some already decided and some yet to be decided.
Cases yet to be decided. Alexander versus South Carolina State Conference of the NAACP is a Supreme Court case that deals with gerrymandering. Gerrymandering is when a political party manipulates district lines so that when it comes time to vote, the district breakdown favors their party. South Carolina's 1st congressional district was considered to be a swing district, meaning that the vote didn't traditionally lean either Republican or Democrat until the 2020 census. Right after the census, the legislature redrew the district maps and they were released in January 2022. The new map split Charleston County into two, putting Charleston and North Charleston, which are two cities, into heavily Democrat-leaning 6th district. This made the 1st district predominantly white or Republican-leaning, so it would no longer be a swing district when it came time to vote. The redistricting was successful because previously, if Republicans won the district, they only won by less than a percentage of the vote, and the same applied to Democrats. So the Democrats won, they only won by a very tiny bit. But after the redistricting, the Republican candidate in 2022 won the district by 14%. The South Carolina NAACP, among others, sued, stating that the redistricting was unconstitutional and violated the 14th Amendment. The United States District Court for the District of South Carolina ruled on January 6, 2023, that the 1st district redrawing was indeed racially motivated, but the 2nd and 5th districts redrawing were politically motivated, so they were to stay as they were. The court ordered a new map to be redrawn on March 31st. This was a partial win for the NAACP. However, the case was appealed on January 27th, and the United States Supreme Court agreed to hear it on May 15, 2023. Arguments started on October 11th, and the case is still ongoing today.
the abortion medication. On March 26, the Supreme Court heard arguments for a very important case on women's rights, the Food and Drug Administration, or the FDA, versus the Alliance of Hippocratic Medicine is a court case around mifepristone. The Alliance of Hippocratic Medicine was formed shortly after the Dobbs v. Jackson Women's Health Center case in 2022. And in December of that year, they sued the FDA over its approval of the drug mifepristone. Mifepristone is the first of two drugs that is used quite often in the United States for abortions, over 60% of abortions. In 2000, the FDA approved it for use, but they placed several restrictions on it. However, since 2016, the FDA has been loosening restrictions, including reapproving the drug in 2019 and allowing the drug to be mailed to patients in 2021. These improvements have only made anti-abortionists more agitated, and this alliance was made to hinder it. In April of 2023, a federal district court ruled against the FDA, effectively banning mifepristone across the United States. But right after this, there was an appeal which was made that reversed the district court's order and kept the old restrictions, but it kept the old restrictions of mifepristone in place. It just didn't ban it, basically. Last September, the Supreme Court agreed to hear the case. This is a very important case because it will determine whether the women who receive more than half of the abortions in the country will even have that option. But this isn't only a case about the FDA's reversal of restrictions on mifepristone since 2016. It is also about whether the alliance has the right to even challenge the FDA on this issue. We should get the decision next month in June, but with the Supreme Court's conservative supermajority in its history on abortion rights, it doesn't look good. Although it did seem like the justices didn't really approve the alliance's right to sue the FDA in the first place.
January 6th and the 2020 election, Fisher versus the United States and Trump versus the United States. Wait. Okay. This year in 2024, the Supreme Court will be hearing cases that will directly affect Trump and his criminal status. The first case is called Fisher versus the United States. On January 6th in 2021, when the Capitol was breached, this is a picture of that, by the way, when the Capitol was breached. Joseph W. Fisher was one of the people who breached the Capitol and entered. He was prosecuted later for several crimes, but one of them in particular were obstruction of a congressional proceeding. And that particular charge has profound cases, as we will see later. And he was charged for obstruction because, as we know, during January 6th, Congress was verifying the votes from the election. So as they breached it, they were obstructing that process. In March of 2022, a district court judge dismissed the obstruction charges that were charged against Fisher. But this decision was appealed to a circuit court by the opposite side. In April of 2023, a circuit court reversed the district court's decision, ruling that Fisher was indeed guilty of obstruction. But when Fisher appealed the decision to the Supreme Court, the Supreme Court is currently hearing the case. This court case is important because one of the charges brought against Trump after January 6th was also obstruction of an official proceeding. And therefore, that means if Fisher's obstruction charge is thrown out or dismissed, then Trump could use that to dismiss his obstruction charge and potentially all of his charges against him associated with January 6th. The second Supreme Court case that affects Trump affects him directly because he himself is on trial. Trump versus the United States is an ongoing Supreme Court case focused on presidential immunity. Back in 2022, the United States Department of Justice was investigating Trump on his charges surrounding the 2020 elections and surrounding January 6th. Trump was indicted on 4 different charges in the district court later that year in 2023, or a year later in 2023. According to his lawyers, the charges against Trump should be dropped since he was president at the time, which gave him presidential immunity. Presidential immunity is basically a policy that presidents aren't criminally liable and they can't be sued while they're president. While presidents enjoy this freedom, it isn't explicitly guaranteed in the Constitution. So Trump's request for presidential immunity were rejected from a district court or rejected in a district court. But later, it was appealed directly to the Supreme Court. However, the Supreme Court rejected the case, so it went back to a lower circuit court. And they ruled against Trump's immunity request. So basically, they said that Trump did not have immunity. So Trump appealed to the Supreme Court, and this time they agreed to hear the case. So they're currently hearing this case, but if the court decides to give Trump immunity, then he won't be held for January 6th. He won't be held responsible for January 6th or for his disinformation in the 2020 election.
Murthy versus Missouri is a Supreme Court case dealing with free speech, social media, and the government. In 2022, after Elon Musk bought Twitter, he hired independent journalists whose jobs was to basically prove that the United States government had been working with Twitter before he purchased it to suppress free speech regarding the 2020 election and the pandemic. While it is true that Twitter took measures to limit the misinformation about the issues, it wasn't to the degree or purpose that Musk claimed. But many Republicans didn't care. They believed that their views on the pandemic and the 2020 elections were being censored unjustly and violating their right to free speech. In March 2023, the United States House of Representatives began looking into it. Hearings began in May of the same year, and in July, it was ruled that tech companies and the government had used their power to remove certain narratives. It wasn't until October 2023 that the case finally made it to the Supreme Court after being appealed, and it is currently ongoing.
Downwind pollution. Ohio versus the Environmental Protection Agency, or the EPA, is actually a combination of 4 cases all centered around a new rule that was made by the EPA. In February of 2020, the EPA introduced the Good Neighbor provision. This is a new part of the Clean Air Act, which was originally passed in 1963. And this provision aimed at making sure the United States met the ozone national ambient air quality standards that were set in 2015 and revised in 2020. This provision puts more emphasis on upwind states, saying that they need to be mindful of the emissions they are sending to downwind states. They were required to submit a plan they were required to submit a plan where they would detail what they would do to reduce emissions, or the EPA would create a plan for them. There are 26 of these states in total, but in February of 2023, 2 states hadn't submitted a plan and 21 had submitted plans that wouldn't make a difference at all. So the EPA created a plan for those 23 states in June of 2023. However, 12 of the states are currently still arguing about their plan, so they don't really count. Okay. In response, several of the states have sued the EPA. The EPA, several of the states who the EPA is trying to made a plan that they have to follow to reduce emissions, but they sued. The appeals court sided with the EPA, and the case was appealed to the Supreme Court last year. These states are saying that they don't want federal intervention, and they're also complaining that the EPA's plan isn't even good. With the conservative supermajority, this case might not turn out the right way for the environment, and this wouldn't be the first time the Supreme Court undermined the EPA. This case will determine whether states have to take more action in fighting climate change, not just for themselves, but also for their neighboring states, and also whether the EPA's plan for all of them has to be implemented.
Guns and domestic abusers, the United States versus Rahimi. The debate over whether domestic abusers should be allowed to possess a gun will soon be decided by the Supreme Court in the case the United States versus Rahimi. Back in 2019 in Texas, a bystander witnessed Rahimi assault his girlfriend or ex-girlfriend when they got into an argument. When Rahimi noticed he was seen, he got his gun and shot at the bystander. The next year, which was February 2020, Rahimi received a restraining order, which, among other things, prevented him from owning a gun. But this order didn't stop him from committing five shootings in the span of 2 years afterwards. The first shooting happened when he tried to sell drugs, but the customer was rude to him, so he ended up shooting that customer's house. Next, Rahimi got into a car accident and shot at the driver. Then he ran, but later he came back, shot at the driver again, and ran off again. The third shooting was when Rahimi fired a gun into the air by some children, and the fourth shooting was similar to the second shooting, involving a car and road rage. Lastly, the fifth shooting took place when Rahimi fired into the roof of a restaurant when his friend's credit card was declined. All of these shootings led to Rahimi's arrest and conviction of unlawful firearm possession. However, Rahimi appealed this conviction, saying that the Second Amendment gave him the right to own a gun, even despite his restraining order that restricted him from using guns. The district court that he appealed to rejected the appeal, so Rahimi appealed to a circuit court. By now it was 2022, and just as the circuit court rejected his appeal, the Supreme Court decided a separate case called the New York State Rifle and Pistol Association, Inc. versus Bruin. This separate case required new gun laws to agree with historic gun laws. And after hearing this decision, the circuit court, which was, by the way, comprised of two Trump appointees and one Reagan appointee, they changed their decision. Instead of rejecting Rahimi's appeal, they actually decided to hear his case and side with him, saying that the fact that he was charged with unlawful firearm possession was indeed against the Second Amendment. And just 2 weeks after this decision, on March 17 of 2023, the United States Justice Department asked the Supreme Court to overturn the circuit court's decision. The Supreme Court agreed to hear the case in June of 2023, and each side began their oral arguments. So if the Supreme Court does decide to side with the circuit court in this decision, then in certain states, people who are violent enough to have a restraining order placed on them will be able to legally own and use a gun. And as a result, many people's lives will be in danger.
Decided cases. Trump versus Anderson is a Supreme Court case about whether or not states can decide who can run for a federal position. The issue began back in December 2020 when Trump told his supporters to protest in Washington, D.C. This led to a riot and storming of the Capitol the following year, which we all know as January 6th. Years went by and Trump began to run for president again, despite losing the last election and being in a lot of legal trouble. In August 2023, two legal scholars, William and Michael Paulson, who are both conservative, published an article in the University of Pennsylvania Law Review that Trump shouldn't be able to run for president based on the fact that the 14th Amendment says no one can hold office who previously took an oath to uphold the Constitution and then engaged in insurrection or rebellion. This would then give states the legal right to remove Trump from their ballots. On September 6, 2023, a lawsuit was filed in Colorado stating that Trump should not be on the ballot. One of the 6 people who filed the lawsuit was the former state Senate Majority Leader for the Republican Party, Norma Anderson. The trial began on October 30th, and on November 17th, the judge ruled that Trump had to remain on the ballot, but stated that he had engaged in insurrection. The case was appealed on November 20th, and the Colorado Supreme Court took the case the next day. On December 19th, the court ruled 4-3 that Trump was disqualified to run for office, stating that Trump not only incited insurrection, but participated in it. The Colorado Republican Party appealed to the Supreme Court on December 27th, and Trump appealed the case on January 3rd. The Supreme Court began to hear arguments on January 8th. On March 4th of this year, the court stated that only Congress could enforce Section 3 of the 14th Amendment. Therefore, the lower courts could not decide whether a candidate was eligible to run for office or not.
Employment discrimination. Sergeant Mudro, hope I'm pronouncing that right, worked in the police force in St. Louis, Missouri from 2008 to 2017. She had a high status in the intelligence division and even worked with the FBI until she was transferred in June of that year. This transfer took away a lot of her privileges and put her in an entirely different role. Afterwards, right after, she filed a discrimination charge against the city and the new captain that had moved her, saying that this only happened because she was a woman. At this time, she also requested to be transferred to other positions, but was denied. Although she got her original position back in February of 2018, she continued to fight. She sued the city, saying that they have violated Title VII of the Civil Rights Act of 1964 by discriminating against her and then retaliating against her efforts to challenge them. Title VII prohibits discrimination in employment based on characteristics like race, sex, and religion. But the federal district and appeals court ruled against her. In June of last year, the Supreme Court agreed to hear her case, and on April 17, 2024, it was decided. In a unanimous decision, the Supreme Court sided with Woodrow. Justice Elena Kagan wrote the majority opinion. They said that an employer could violate Title VII by transferring someone, even if their new position is at the same level, basically at the same level as the old one. Previously, courts would dismiss cases where people couldn't prove that they were at a significant disadvantage because of their new position. But this is no longer the case. Now, an employee can claim discrimination if they are disadvantaged by a job transfer, and it can be connected to one of the protected rights under Title VII, like race or gender or religion.
Social media critics, O'Connor versus Radcliffe or O'Connor, Radcliffe versus Garner, and Linkty versus Freed. Recently, the Supreme Court decided two cases that focus on the First Amendment. One of those cases was O'Connor Radcliffe versus Garner. And in 2015 or 2014, Michelle O'Connor Radcliffe and TJ Zane have become board members for a school district in California. They created social media accounts for their campaigns and continued to use those accounts to post updates about the board. But two people, in particular, Christopher and Kimberly Garnier, were longtime critics of the board. Since none of their concerns were being taken seriously, they started spamming Radcliffe's and Zane's social media accounts with their comments and complaints. For example, they left over 200 of the same comments on each of the tweets Radcliffe had ever posted. Because of this, Radcliffe and Zane blocked the Garniers from their social media pages, effectively silencing them, or at least on social media. The Garniers sued, stating that their First Amendment rights have been violated. A district court actually ruled in their favor, and when the decision was appealed, a circuit court also ruled in their favor. So the case was appealed to the Supreme Court. And meanwhile, back in 2014, another similar situation was unfolding. James Freed had created himself a Facebook page, and when he became city manager of Port Huron, Michigan, he made sure to put that position on his page. Another citizen in the city, Kevin Linkty, disapproved of how Freed handled the COVID-19 pandemic, so he began to comment on Freed's Facebook page, basically criticizing his actions. Now, unlike the Garniers, he didn't post a ridiculous amount of comments. In fact, he only posted 2 that criticized Freed, but that was enough for Freed to block him on his Facebook account. So Linked sued Freed, also saying that his First Amendment rights were being violated. And eventually, this case was also to be held by the Supreme Court. So on March 15 of this year, 2024, the Supreme Court decided in the case Linkty versus Freed, And it was also effectively deciding O'Connor-Ratcliffe versus Garnier at the same time. In a unanimous decision, it was ruled that, quote, a public official who prevents someone from commenting on the official social media page engages in state action under a certain law only if the official, one, possessed actual authority to speak on the state's behalf on a particular matter, and two, purported to exercise that authority when speaking in the relevant social media posts, end quote. So basically what that is saying is that a leader can be in legal trouble if they have real government authority and if they make it seem like they are using that authority when they block somebody on social media. So the Supreme Court didn't specifically decide the two cases, Radcliffe versus Garnier and Linkty versus Freed, but they made this statement and then they sent those two court cases back to lower courts to revisit their decisions based on this new rules that they set in place. In summary, so we looked at cases both yet to be decided and three more cases that were decided. So one case that was yet to be decided was Alexander versus South Carolina State Conference of the NAACP. And basically that court case deal began when South Carolina, after the 2020 census, they redrew district maps, and the way they redrew them favored Republicans. So instead of Republicans winning by 0.5% or less than 1% in an election, they went to winning by 14%. So it's obviously favored the Republicans. So the NAACP sued them because of this, and the Supreme Court will be deciding that if the South Carolina's legislature did violate the 14th Amendment by drawing the maps in this way. A second court case we looked at was the FDA versus Alliance for Hippocratic Medicine. And that court case began when the FDA was continuously loosening restrictions around the drug mifepristone. And I believe they took a substantial, they removed a substantial restriction in 2019-ish. So they got sued, and the Supreme Court is soon to decide whether they can continue to loose these restrictions or if they just ban the drug altogether. And then we looked at another case called Fisher versus the United States. Well, it's two cases, both roughly similar, Fisher versus the United States and Trump versus the United States. So in Fisher versus the United States, Fisher appealed to the Supreme Court to overturn his obstruction charge that was brought against him when he went into the Capitol on January 6th. And the way that deals with Trump is that if his obstruction charge is overturned, then Trump could use that as an excuse to get his personal obstruction charge related to January 6th overturned. And if he gets one charge overturned, then he could potentially get all of them overturned. That's Trump. And the second case, Trump versus the United States, deals directly with whether Trump has presidential immunity from what he did in January 6th and from his disinformation that he spread around the 2020 election. Three more cases that are yet to be decided that we looked at are Murphy versus Missouri. And during that case, or during the 2019, 2020-ish pandemic area, that Twitter was using their algorithm or however they do it. They were using that to limit misinformation spread on their platform on Twitter. So Republicans did some investigation, and when they found out that they did limit misinformation, they claimed that Twitter was violating free speech. And now the Supreme Court has to decide whether Twitter can limit misinformation or the fact that limiting information is violating free speech. Another case we looked at was all of these different organizations, Ohio, all of those versus the EPA. And basically, the EPA passed the Good Neighbor provision, which requires states to lower their emissions by making plans to lower those emissions and then submit those plans to be verified by the EPA. But some of those states didn't submit plans, and some did submit plans, but the plans didn't really work. So then the EPA just started creating their own plans to give to states, but states didn't like that. They didn't want the government intervention, so they sued the EPA. And now the Supreme Court has to decide whether the EPA can intervene and force states to lower their emissions, or if it's a states' rights kind of thing. And the last case that is yet to be decided that we looked at was the United States versus Rahimi, where Rahimi was criminally charged for 5 shootings, for 5 shootings. And the Supreme Court has to decide whether whether the Second Amendment allows people to have a gun even if they have a restraining order or other similar restrictions placed on them that prevent them from using a gun. And then we looked at 3 cases that are yet to be decided, or 3 cases that have been decided already. So one of those is Trump versus Norma Anderson. And Norma Anderson was one of the 6 people that filed a lawsuit to remove Trump from the election ballot because during the January 6th insurrection, we know Trump was involved directly in that. So they claimed that the 14th Amendment, they claimed that Trump violated the 14th Amendment by being involved in an insurrection. And in violating the 14th Amendment, he voided himself from being able to run in an election. So the Supreme Court decided that only Congress can truly enforce whether Trump can or cannot be in an election based on his actions on January 6th. So they didn't technically side with either side, but they made it a lot harder of a process to get Trump off the ballot since Congress has to go through that entire process. Another case that was decided already that we looked at was Muldrow versus the city of Luis. I don't really know what that's short for, but that's the court case.
St. Louis.
Oh,
Louis, Missouri.
yeah, that makes sense. St. Louis. Basically, in that case, Sergeant Muldrow she was transferred to a different job, and in that transfer, they rejected, or not rejected, but they removed a lot of her privileges that she had at the previous job. So they sued the city, or she sued the city for discrimination based because she was a woman. And the Supreme Court actually sided with her in the case, saying that an employee can indeed file for discrimination if they are disadvantaged by transferring to a different job, or when a job transfers them. And lastly, the final case we looked at that was decided already was Radcliffe versus Garnier and Linkty versus Freed. And these are both kind of decided in the same Supreme Court case. So in both of those cases, there were local government or local leaders that blocked people who criticized them on social media. And those critics sued the local leaders, claiming that they were violating their First Amendment right to free speech, even if they were criticizing them. So the Supreme Court didn't side with either cases. They actually sent the case back to the lower courts to decide. But what they did say is they set some rules in place on whether officials can block people. I know one of the rules was whether the official is acting as if they're acting on the behalf of the government when they block that person. And the other regulation was whether that official actually had government power. So those were the 3 court cases that we looked at that were decided already. And all these court cases in general are important to this movement because a lot of them connect directly to Sunday law issues. Like we saw some based on gender discrimination, which was right here in Muldrow versus the city of St. Louis. We also saw some directly involving Trump, and we know Trump is a prominent figure in this movement. Well, not in the movement, but prominent figure that this movement deals with because he's basically the face of the Republican Party. And we also saw some other court cases dealing with guns and restrictions around guns, which is also an issue that Republicans take very seriously and an issue that we can see being connected to the Sunday law.
Okay, so does anybody have any questions about the lesson or just any or comments? on the lesson or just the message? Okay.
Now it is quiz time. First question, what is the main issue in the Alabama versus South Carolina State Conference of the NAACP Supreme Court case? What was the main issue? E, G, another E,
Is it H?
and H. And it is E. So the Supreme Court case was about the the state Colorado redrawing the maps. Not Colorado, South Carolina. South Carolina redrawing the map and gerrymandering it so the Republican Party had more votes in a swing part of the state. Next question. What is the main issue in the FDA versus Alliance for Hispanic Medicine Supreme Court case? What was the main issue?
You said Alliance for Hispanic Medicine.
Did I say that?
Yes, you did. Hippocratic medicine.
G, and I think that was a B for this one. I don't remember.
I'm sorry, can you repeat the question?
What is the main issue in the FDA versus Alliance for Hippocratic Medicine Supreme Court case?
G?
A G, an H. Another G. And the answer was G. It was about this abortion medicine being banned in certain states. Third question. What is the main issue in the United States versus Rahimi Supreme Court case? What was the main issue? We have an A. Another A. What was the main issue in the United States versus Rahimi Supreme Court case? A third A. And that is correct. It was about domestic abusers' right to own a gun. Fourth question. What is the main issue in the Trump versus Anderson Supreme Court case?
F.
F. Another F. And it's actually H. States' rights regarding ballots. Oh, I see what it's like that. And last question. What is the main issue in the Muldrow versus City of St. Louis Supreme Court case? Muldrow. Main issue in Muldrow versus Supreme Court case. Versus City of St. Louis Supreme Court case. A B, another B. And yes, that's correct. It was a B, workplace discrimination. So thank you everybody for participating in the quiz.
So thank you everybody for coming. If you have questions about the lesson or any of the past lessons or about the message in general, if you want notes or updates or recordings, you can contact us at youthprophecygroup@gmail.com. And our next meeting will be on the first Sunday of next month, which is June 2nd.
Let's close with prayer. Dear Lord, thank you for always being with us and for protecting us and bringing us to the start of another month. Please continue to give us your Holy Spirit and your power to do your will. Thank you for providing for all of our needs, and please continue to be with us through this day and through this upcoming week. Thank you for allowing us to see the issues that are important to our movement and the events that are happening in the world. And thank you for calling us to be part of 144,000 and letting us see what's going to happen in the very near future. In Christ's name, amen.